So the ministry is on. Ms. Fiola, you're going to lead? Oh, please go ahead.
Conrad Allen Brown from the Ministry of Legal and Constitutional Affairs, Legal Officer.
Erica Simon, Legal Reform Department.
I'd like the last, yes, can you just introduce yourself, but if I were asked by the judge to say, can I recognize you, I would not be able to say yes. So if you just remove your mask for a second so we can see who you are. There we are. Then I can say, yes, Your Honor, I did see her in the meeting. Thank you very much.
Thank you. Good morning, everyone. We are going to be reviewing the matrix this morning.
Yeah.
One of the things we'd like to point out is that the OSI MIC did a presentation earlier, and those recommendations were not included in the parliamentary matrix.
Right.
So we have included them to make sure that we look at all the presentations and all the recommendations, all the submissions that were made.
All right, Mrs. Evans-Roberts, continue. Go ahead.
So we're looking at matrix, the sections. We're looking at it section by section. Section 2, interpretation and application of the Act. We have the different entities that have made presentations.
Mr. Chairman, might I interrupt, and I apologize. I don't know if the others are experiencing it, but the sound from the chamber is rather low.
One thing we're going to ask you to do is speak closer to the mic, into the mic. Yes, pull up a little closer. And then,
I'm not sure if it is the speaker, Chairman, because you're low as well.
Okay, then I'm going to
ask the IT issue.
I'm going to ask the ICT experts to work on this for us. You can certainly hear what Senator Golden Campbell has said. Yes. So if you will, Madam Clerk, we're contacting them to, you want us to wait a few minutes then, Senator Golden Campbell? You would prefer us to wait a few minutes till we try and get it fixed, or you can hear us sufficiently to continue? She's clearly not hearing us at all. Senator Golden Campbell, are you muted or? Hello? She's not hearing, so we have to wait. Or she muted herself and not responding. I think she's muted. Senator Golden Campbell, can you hear us at all? I think that's a no. Okay. I figured that, yes.
Hearing you now, Chairman.
Clearly?
Loud and clear, Chairman.
All right, so we're on. Thank you very much. And we will start again with Mrs. Evans-Roberts.
Yes, so we are looking at the different sections, and we commence with section 2, which is the interpretation section of the Act. And the first recommendation was to amend the definition of receiving order. And it was agreed that that was an incorrect reference to receiver, because based on section 162 of the Act, when a receiving order is made, it's a trustee who is appointed and not a receiver. So that recommendation is made for the definition to be amended. There's also a recommended amendment of the definition of books and records to include non-documentary evidence, something to include. It is recommended to broaden the definition of books and records. They're saying that the current definition does not include documents that are deemed non-documentary. But we are of the view that that definition incorporates all forms of recording and documents. that. Yes. Let me see if I can find that recommendation. It is.
No, don't.
I don't need to.
She's modified with your explanation.
Yes. And there is a recommendation as well to define public sale in the Act, but public sale is not used in the Act at all, so there's definitely no need to define it.
Okay.
2 other definitions were recommended. The word electronic is used in the Act in different sections, but it was never defined. So now we are including it, and the definition is given based on the Electronic Transaction Act. And the words working days, because we're now including working days, there's an amendment for 21 days for the meeting of creditors to 30 working days. So we are now including the definition of working days, and it is used based on the SIPA Act. We're using that definition. That's going to be included in the IA as well to make sure all the definitions.
Where you're still in
coincide.
section 2, or you moved to
Still
section?
in section 2, Minister.
But I don't see that what you just said here on my
Those were
matrix.
the recommendations, original recommendations from the OSI MIC, but they were not included in the parliamentary.
Okay, so you're just saying you're going to include them?
Yes.
Okay.
And we need everybody to be aware of all the recommendations and the submissions. So we've included all of the submissions today. So we move on to section 3.
Yeah.
The objects of the Act. There is a recommendation to add when so reasonably demonstrated to the definition in section 3. And we are of the view that this doesn't add anything to it. At least it introduces a new concept of reasonable. And reasonably is always a subjective test. I don't think the Act, yes, it doesn't add anything, and it would include something that we don't want to be going to court to find a definition for. Certainly.
Yeah, you're just creating court cases if you use a term like that.
Yes.
Because that was a good reason for somebody to require a clarity in court.
Definitely, Minister. There is also a recommendation to add the word all, and we have accepted that one because in this context, it needs to be clear that all creditors, including secured creditors, yes?
Right.
Are included. So that was accepted. And a new subsection C, ensuring a timely winding up and exit of non-viable companies. That was not captured in the present definition, and we are of the view that that is should be added. Yes, it definitely adds clarity.
I must ask members that as the clarifications are outlined in the matrices, if there are any comments, that's the time to make a comment or ask for clarification or add something to it. So keep going.
Yes. And
Excuse me,
another.
Chair, I had up my hand, but I don't think you can see me online. Harissa Mesada here from Attorney General's Chambers. Right. It's along the points that you just made a while ago, because I noticed that a lot of recommendations are being made, and I wasn't sure of the procedure. Is it that after each recommendation, the committee will just indicate if they're in agreement? Because each point we need to know if there's agreement or not. So I'm not sure if you want to do it section by section and then a decision is made, or I'm not sure the approach.
I would take your advice and go section by section. So I'm going to ask the members if they would agree to this submissions made in section 2, which we've just completed, and treat them as accepted as presented by the supervisor of insolvency, the acting supervisor, Mrs. Fiola Evans-Roberts. So we're going to ask that section 2 on the matrix be accepted as presented. No objections, we move it along, and we then, when we come to the end of section 3, we will ask the same thing. So if you continue in section 3 as you've just started. Thank you very much. I did not get the name from the Attorney General's office. Ms. Masado?
Yes, Chair, Carissa Mesado.
Thank you very much for your intervention. Go ahead, please.
And the other recommendation for Section 3 was to change companies to preservation of businesses as a going concern. That submission was not accepted because the Act defines companies, not businesses. And if we're going to introduce businesses now, we'd have to have a definition of that. And we are of the view as well that to say
We stick to company.
preservation of businesses, yes, we definitely will stick to companies as defined by the
Right.
Act. That's for Section 3, so
Any comments? And if none, then I'm going to take that the members have agreed with the changes and submissions as outlined on the matrix for Section 3. So done, we move to Section 4.
4.
2B.
4.2b.
Right.
The phrasing is cumbersome. There is some uncertainty as to which notice. There are 2 notices in this section, and we agree that it is cumbersome, and there is a recommendation for it to be clearer that the 10 days refer to the notice.
I'm going to ask you to do one thing, Ms. Evans Roberts. Whenever you mention the suggested change, say who is suggesting. The bar, in this case, it's the Bar
The
Association.
Bar Association.
Yes.
Just for clarification.
Senator Allen, yes.
Thank you very much, Mr. Chairman. Just for clarification, Mrs. Roberts, in Section 3, where you make reference to the recommendation that was made to change companies to preservations of businesses, your reason for not accepting it, which we have accepted your reason, is that in the Act there's no reference to businesses but instead to companies. But on the recommendation that is on the document, it doesn't state what you have just said. And maybe that, I mean, for the documentary purposes, we may want to be consistent with what you say and what is here. Reasonable?
Reasonable. Thank you.
You are accepting the suggestion from Senator Allen?
Yes, yes,
And
Minister,
it
I
will
am.
be included. Thank you very much. Continue.
Back to 4.2b, the phrasing is cumbersome. We agree with that because there are 2 notices, and we are unsure as to which notice the 10 days refer to. The amendment will ensure that the 10 days refer to the notice of the secured creditor to enforce the security and not to the notice of intention to file the proposal. As it is now currently, we are uncertain. It's not clear to which notice the 10 days refer to, as read now.
And so you will make that clear.
We will make that clearer, yes, Minister.
Any comments or objections? None. Then we accept the suggestion for 4.2b as just outlined. We're moving to Section 11.
Section 5 was the OSI MIC had a recommendation for that amendment.
No, ma'am, you lost me.
Section 5.
The next one I see is Section 11.
As we indicated, Minister, we have included the recommendations of the OSI. We discovered that they were not included in the matrix, in the original matrix.
But it's not on the matrix that you have given me.
Yes, it was in the original presentation that we did. We just discovered, Minister, that they were not we had the recommendations of all the other presenters, but not for the OSI. Thank you. So I see you have the
I
recommendations
see
of the OSI.
the document being circulated, but will it be available for the people online? It was circulated. All right, so the answer is yes. All right. So it's available to people online.
Yes, Minister, it was originally circulated.
All right, and
Yes,
amendment to section 5 under section 5(1)(a).
yes.
All right.
Yes, Minister.
Please continue.
So we will remove the words "to whom the proposal is made"
Yes.
to allow the state to apply to all creditors. Read as it is now, it appears as if the stay is not applicable to all creditors, but it is. And that is in line with other other legislation as well.
That's right.
So we are removing that.
Thank you. Moving.
Are you, we
That's-
should
so
say
that's-
whether we agree.
So that's
Minister?
section 5.
Section
There
5.
seems to be no disagreement. I'm pausing. I hear none. So we move on.
Section 11, there is a submission from the Jamaica Bar Association to delete subsection D as it is covered in subsection E. But the trustee of an insolvent person's property is not the same as the trustee of the estate of a bankrupt. The trustee of an insolvent person could be the trustee under a proposal. Minister, it's not the same as
This is the amendment of section 11.
Section 11.
Okay.
Yes. So definition of insolvent person does not include a bankrupt. So the trustee of a bankrupt person is not the same as the trustee of an insolvent person. They are separate.
They're different.
They are different, yes.
Okay.
So we are not accepting that recommendation. That's section 11. Are we agreed?
Yeah. No objections. Pause. No objection. We take them that members have agreed. We move on to
Section 11B.
section, no. I have section 14.
Yes, between both of them.
Section 11.
And there are two other amendments in section 11 as well.
Section
I'm
11D
sorry.
and E is what you're talking about now?
Yes, yes, Minister.
Okay, good.
So we're going to,
So do us a favor. When you flip from the matrix to the document to say we're moving, since they're not on one sheet,
Will
you
do,
have
will
to
do.
keep us aligned. Thank you very much.
will do, Minister. We're on the matrix now from the insolvency,
All right.
and it said delete subsection E. There is another amendment as well to replace the word liquidator with the word trustee. And that is acceptable, of course, because liquidator was removed from the act.
Yes.
So that is definitely an error. And the final one is to incorporate a provision for creditors to initiate a proposal process. And originally that was presented, but after further consultations with other stakeholders, we decided that recommendation would not for this time, to allow creditors to initiate proposal. Under the present regime, the creditors can participate in the proposal regime at any time. So we will allow them to participate when the debtor presents the proposal. So we will not include a creditor being able to initiate the proposal process.
Okay. We did have quite a bit of discussion on that.
We did, Minister.
All right.
We did.
I don't hear any objection. I have paused, so we can move on.
Section 14, that is on
You're going to take
the
section 14
OSIs.
before 13?
They make OSI because 14 was not on
You're
the.
going to take 14 before 13 on the matrix?
13. Sorry. Years. Somehow I'm not having 13. I'm not seeing 13. Please give me a minute. There is no amendment to section 13. Do you have 13?
It says insolvent person may file cash flow statement, report, etc. That's on the matrix. And the 1A does not impose a formal duty on the trustee. Have you looking at the matrix or you're not?
I'm looking at.
Look at the matrix and you see section 13 after section 11. And that would come before section 14, which you were starting to address. 14 is on the matrix,
Oh, yes.
below 11.
Somehow we missed that one.
Sorry, 13 is on the matrix before the 11, right, or rather, right after 11. And I imagine that would come before 14.
Yes, it does, Minister. And this is a recommendation for the insolvent person may file a cash flow statement, report, etc. There was a recommendation from Patterson Mayor Hamilton
Yes.
that the IA does not impose a formal duty on trustees to monitor the business.
Yeah.
But we're of the view that Section 28 does, because it requires the trustees to monitor the business.
All right, and
Yes.
so it's covered.
It is covered. It is
Right.
already covered. Yes.
I have paused. No comments. Means that the members have accepted. We move on to the next one.
Yes. And Section 14 is now on the
distributed sheet.
distributed sheet. Yes, the recent is the last distributed sheet.
Yes.
Yes. And that is this.
It's number 4 on the distributed sheet, dealing with amendment to Section 14 of the
14.
Act.
Assignment deemed to be made where cash flow statement not filed within the prescribed time. And we are recommending that the 21 days be enlarged to 30 working days, because this gives the trustees adequate time within which to prepare for the first meeting of creditors.
Right.
First meeting of creditors is very important, and we discovered that 21 days not adequate time.
And
So that's a
30
proposal.
working days give you about 35, 38 days.
Certainly.
So to get your act together. That sounds like a reasonable recommendation. I hear no objections, so I think you can move on.
Section 15, recommendation from Jambar.
Which is on the matrix.
It is on the matrix.
Thank you,
on
ma'am.
the Matrix, yes. The effective difference between subsection E and C is not clear, and the recommendation is to delete both and replace with CARICOM's model bill proposed provisions. It is agreed that the model bill proposed provisions very much clearer than what is presently in the IA. The provisions from the model bill is the creditors as a whole would be materially prejudiced if the application under this section is rejected, and that captures both our B and C. So we are recommending that B and C be deleted as recommended by Jambar, and the model bill proposed paragraph be accepted.
And that's number 16. Sorry. That's
Section 15.
Section 16 on the matrix. Yes?
Section 15.
15, we just did the 30 days and we agreed on that.
That was 14.
No, ma'am, Section 15, court may terminate the 30-day period. Oh, that was, sorry. 14 was the cash flow.
Yes.
Yes, and we agreed that, so we're now working on 15 on the matrix, which is a court, another 30-day business. So, all right, can you repeat that for me?
Excuse me, Chair. I think on the section 14,
Yes.
on the ministry's matrix, there was another recommendation. So is it that we're not going along with that again, or did you just forget to mention it? It was
No.
about inserting a new section 5A. I think that's in relation to section 14.
We did
So you could just
section,
double check.
we did section 13, and then we moved, which is on the matrix, and then we moved
Right.
to the later distributed item, which
Right. Yes. So there were two proposals there, but you only discussed one. So I was just querying whether the second proposal still stands.
I see there was 14.4B,
Yes.
and can you address that, Ms. Evan Roberts?
Yes, there was another amendment. Sorry about that. We missed that. The section is to be amended to include subsection 5A, which provides that the supervisor is to certify a newly appointed trustee where that trustee has been appointed at a meeting. What presently occurs is that when a trustee is removed, there is no certificate issued to know that a new trustee is appointed. We definitely need a certificate appointing the new trustee to provide certainty, and that trustee will be able to say, I am appointed by the supervisor. So we are including that.
Thank you, Ms. Rosado, catching that for us.
Yes.
And
Thank you.
I have paused and I haven't heard any
Can
suggestions.
I make a point, Chairman?
Yes, Dr. Dunn, go ahead.
Good morning, all. When a proposal is rejected, as in this case now from Jambar, do we normally give them an opportunity to comment on the rejection, or do we just move on with the bill itself?
The whole point of the Joint Select Committee is for people to come and submit and recognize that the final decision remains with the committee members. It's not a negotiation. It's really for information and for consideration. And once it's considered and the recommendation comes, the committee, the Joint Select Committee must decide if they will accept the suggestion submitted by the submitter, in this case, the Bar Association, or will accept the rendition and the submission made by the ministry and the agency. And in this case, once that is done, the record is there in Hansard, but we don't go back and say, well, this is what we do, because it's a public hearing. They're quite able to, they might even well be sitting in to hear this, and they have the right, but we don't go back and say, no, we're not going to accept it. This is, what we do is publish what has been accepted.
Noted, Chairman. Thank you.
Doc. Thank you, Doc. Continue, please. So the committee accepts the second part
Of Section 14.
of Section 14, which allows us now to move back to Section 15, which we were about to address.
Yes. The submission was to delete subsection B and B and adopt the...
Section 15 is on the matrix.
Yes, it is.
Right.
And to accept the Caribbean Model Bill provisions, and we are saying that that does make the act clearer.
And you're recommending
And we are
acceptance.
recommending that it be accepted, yes.
All right. Pause. No comment. The committee accepts that suggestion and requests that we move to the next item.
Yes. Section 16,
Section 16 again on the matrix.
that's on the matrix. And this is a recommendation from the Jamaican Bar Association as well, that there are 13 measures contemplated by the Caribbean Model Bill in relation to the proposal regime, and we are recommending that these recommendations, these 13 measures, be accepted because it does enhance the proposal mechanism. Because these are measures that the trustees can take, and having read them, it is agreed that it definitely improves and make clearer the actions that the trustees should take under the proposal mechanism. So we are recommending that those measures be accepted, be adopted. It will be a new section, but we are recommending that it be accepted.
Any comments?
Importantly, there was a recommendation that there was an idea that the trustees are not required to monitor the business. In this section, it is explicitly stated that the trustee is required to monitor. So we are getting a clearer provisions
yes.
if adopted. Yes.
Pause. No comment.
My only comment,
Yes.
Chair,
Yes,
and I
Ms.
know that
Masada.
13 measures are being contemplated, but I'm not sure the committee is actually aware of the content of the measures. So I'm not sure if that could be provided to them or read to them or a summary of it so that they can decide if this is something that they are going with.
7th, Robert.
We do have a copy of the model bill. Do you have a copy? Please give me a minute.
Indeed, if it's not presented to the committee, we cannot accept it. So if you're recommending something here that we haven't seen, there is no way we can accept it. We will not accept it.
I guess the recommendations, because they were so long, they were not typed out by the Jambar Association. So
No, that's not Jambar.
Yeah.
Sorry. You work in my ministry, you're making the submission. If Jambar doesn't present it, you get it from them and you submit it. But if it's not submitted, Ms. Masada is absolutely right, we will not accept it. We can't, if you'll allow me, accept a puss in a bag.
Guided, Minister.
So what happens now? This will have to be resubmitted.
May we be allowed to resubmit to the provisions that is in the
Yes.
provisions that are in the model bill?
If there's any other item like this where it is new, we have never seen it, it must not be submitted unless what is being recommended is presented in detail so that we can be properly advised and make a decision. I thank you for that, Ms. Masada.
Guided Minister.
All right.
We move on to section 17,
Yeah.
commencement of proceedings for a proposal, and that is on the second.
That's the more recently
More recent,
distributed data. It's item number 5 on that sheet, on that document. Go ahead. So we will not accept
Section 16.
16. All right? Thank you.
Until?
As presented on the matrix. We have to get better particulars. Go ahead.
So for section 17, the section will be amended to include a requirement for the proposal to be filed on the supervisor. Presently, there is no requirement for the debtor or trustee to file the proposal with the supervisor. We're making that explicit in the act that it ought to be filed with the supervisor. It's being practiced, but we are making sure that it's included in the
You're
act.
codifying it.
We are codifying it, yes.
Fine. That covers section 17.
Section 17.
There seems to be no comment or objection. So taking it, recording it, that the committee has accepted that submission. Next.
Section 19.
On the matrix.
On the matrix, yes. Recommendation by PwC to amend the time to extend from 21 days to 30, but as we have heard before, that was already addressed. So wherever in the act there is this requirement for 21 days for the first meeting of creditors, it will be amended to the 30 working days.
We've already accepted that, so we can move on from this as accepted
Already
as well.
addressed. Yes. Section 20.
On the matrix.
On the matrix, recommendation by Jambar, the words and the creditors may accept be a footer and not part of the subsection. Jambar is correct. We are recommending that this be changed to provide clarity to the section. So, yes, presently it forms part of the paragraph as if it is not a footer because both apply to the sections above.
All right, that seems to be straightforward.
Yes.
No objections. The committee is accepting submission as for section 20 as outlined on the matrix.
Section 23 on the matrix. Recommendation by Jambar. Recommend that the measures contemplated in the Caribbean Model Bill, which specify the purpose of the adjournment, be included. And this is similar to, unfortunately, Minister, we did not submit all the recommendations.
So you will resubmit this?
We will submit the provisions in the CARICOM draft bill.
So that members can read it and digest it and
Yes.
decide on for or against, yes.
Yes, so that's for section 23. Thank you. May I withdraw that, Minister? On the matrix itself, it is there. This
Where?
was written out on the matrix for the parliamentary matrix, this one.
Oh, you mean the big one?
The big one, yes.
The big one
It's
with the
on
fine,
the big one.
with the fine writing.
Yeah. That's on page 8. Yes. So you do have 3.
This is, remember we said we would, just to remind the committee, we said we would give you a matrix that would be a synopsis of what this big parliamentary fine writing one would be.
Yes.
So if you want to check what is there, Ms. Masada, you may or may not have been in that meeting, so the truth is that the matter is here.
Yes, I have it here. I have a number of different matrices that I'm following, so I have it here.
Right. So we could address it now.
Yes.
So if you would take us to which page you say we're on?
Page 8.
Page 8. That's dealing with 70. That's dealing with which number?
Section 23.
You're going to go. What about the first number that we said we wouldn't deal with?
Section 16.
Yes.
It is also there.
All right. So take us back. Let's go back to 16.
Section 16.
Because I don't want to have to deal with something again if we can deal with it now.
Correct, Minister. We definitely
And
would prefer
page,
that as well.
section 16 is found on which page of the mother
Page
document?
7.
Page 7. Yes,
mo-
that's the mother document.
And these are the considerations, the measures that we mentioned.
You want to walk us through it very
Yes.
quickly?
1, sale of the whole or part of the debtor's property, transfer of the debtor's property to creditors through settlement, pledging of the debtor's property. So these are the things that the trustee will be empowered to do under the proposal regime.
That's number 3 on the mother document, Roman numeral 3.
3, yes. 4, termination of unprofitable activities and a change of sphere of entrepreneurial activity. Under the regime, when there is a bankruptcy, all the assets vest in the trustee, so the trustee can just do what they want. Under the proposal regime, it is not so.
Yes.
So we are empowering the trustee to be able to do that under the proposal regime. 5, amendment or termination of unprofitable transactions. 6, debt restructuring, that is extending the terms for debt repayment, rescheduling, releasing from liabilities. 7, debt refunding through securities. 8, levy of execution on accounts receivable. 9, receiving a new loan. 10, undertaking new investments. 11, reorganization of the debtor. 12, issuing new shares or buyback. And 13, any other measures as prescribed.
Again, it's not very detailed, but it's very clear.
Very clear.
Because it's enumerated and therefore very easy to follow.
Yes.
So if members have any objections, and I personally have none, because it gives clarity to what we're trying to do.
Yes.
And now we have read it, and we can read the other ones as well, because this mother document is here. Right, I give a little longer pause, so somebody else might be reading it slowly.
In relation to 16, yes.
In relation to 16. But having paused this long time, I hear no comment, so we're going to take it as the committee is accepting that Jamaica Bar Association for the CARICOM to accept the kind of rules that the CARICOM has.
CARICOM recommendation.
And that settles number 16 on the matrix, right?
Yes, yes, Minister.
And we're now moving to number 23,
Number 23,
which is on page,
page 8 of the matrix, and Miss
the mother document is page
8.
23 is page 8.
Page 8, yes. Yes, Minister.
So let's see what it says.
Ms. Allen will be reading that section. There are
Lawyer Allen. Okay, Lawyer Allen, go ahead.
So the provision to be adopted reads, to enable a further appraisal and investigation of the affairs and property of the debtor to be made or to be made. I think that's an error, so it should be to enable a further appraisal and investigation of the affairs and property of the debtor to be made or for the examination on the oath of the debtor or of such other person as may be believed to have knowledge of the affairs or property of the debtor and the testimony of the debtor or such other person, if transcribed, shall be placed before the meeting after any adjournment and may be read in court on the application for the approval of the proposal.
And since there are non-lawyers listening to this, you want to quickly say, Ms. Evans-Roberts, exactly what you intend.
So these are reasons for adjourning a meeting. So at the first meeting of creditors when they...
Again, that very important first meeting.
That very important first meeting, yes. And failure to do some things can result in bankruptcy.
Yes.
So we want to have these provisions that are clear, that meetings can be adjourned for these reasons. It won't lead to bankruptcy. They have reasons to adjourn the meeting and to come back. Yes.
Thank you very much. I have paused. There seems to be no comment from committee members. We're going to accept 23 as outlined on the matrix. No, actually, yes. No, the matrix is a matrix.
Matrix,
The
yes.
big one is the mother document. All right. Continue, if you will.
We're section 28. Provides for the court may direct the trustee to have access. The JAMBAR recommended that the language contemplated in the CARICOM model bill, which expands the time and persons to whom reports be given, be adopted. And of course, we will go to the mother document, yes. Section 28.
Go ahead, Ms.
Right.
Lawyer Allen.
It will read, the trustee named in a proposal in respect of an insolvent person shall file a report on the state of the business and financial affairs of the insolvent person containing the prescribed information with 1. The supervisor immediately after ascertaining any material adverse change in the insolvent person's projected cash flow or financial circumstances, and 2. The court at or before the hearing by the court of any application under Section 48, which deals with the aggrieved creditor, may apply to court for removal of a stay. Section 49(5), which deals with agreements not to be terminated or adhered to. Section 67(3), which addresses deemed assignments. Section 72(1), which addresses court may deem proposal to have been refused. Section 71, which deals with the court may approve or refuse proposal. Section 78, the court may assign rights and obligations of debtor. Section 79, disclaimer or resiliation of agreements. Section 80, interim financing. Section 81, the court may order security or change to cover certain costs. Section 82, restriction of disposition of assets. Section 83, critical suppliers, or Section 85, which addresses the removal of directors and filling of vacancy by court. And at any other times that the court may order, send a report in the prescribed form and manner to the creditors after ascertaining any material adverse change in the insolvent person's projected cash flow or financial circumstances, and these shall send a report in the prescribed form and manner on the state of the insolvent person's business and financial affairs to the creditors and the supervisor at least 10 days before the meeting of the creditors referred to under Section 69(1), which addresses meeting of creditors, is to be held. Subsection 3, an interim receiver who has been directed under Section 53, 3A, which addresses the appointment of interim receiver where notice of intention or proposal filed, they are to carry out the duties set out in subsection 2, in substitution for the trustee shall deliver a report on the state of the business and financial affairs of the insolvent person containing any prescribed information to the trustee at least 15 days before the meeting of creditors referred to in section 69(1), and the trustee shall send the report to the creditors at least 10 days before the meeting of the creditors.
That's
Right.
a lot, but it's only dealing with time and the persons to whom reports should be filed.
That's right.
So it sets it out clearly, what the reports should contain, the time they should be filed, and on whom they should be filed. That's it.
Thank you, very clear. I hear no objection, so committee will accept section 28 as submitted and read into the record. Next, 28A.
28A, this is a new submission for a new section, submission by Jambar, and it's a recommendation again that provisions contemplated in the Caribbean Model Bill be adopted.
On page 9
On page 9
of the mother document.
Yeah.
Go ahead.
And this provides that the court may, on application by the trustee, the interim receiver, if any, appointed under section 53, where notice of intention or proposal is filed, or a creditor at any time before the meeting of creditors declare that the proposal is deemed to have been refused by the creditors if the court is satisfied that A, the debtor has not acted or is not acting in good faith and with due diligence, the proposal will not likely be accepted by the creditors, or C, the creditors as a whole would be materially prejudiced if the applicant under this subsection if the application under this subsection is rejected, and 2, if the court declares that the proposal is deemed to have been refused by the creditors. This is providing for an earlier step to be made. We are still under the proposal regime. If creditors realize that this proposal is not going to be, it's not a viable one, they can take steps to have the court declare that the proposal is non-viable even before the meeting of creditors. Presently in the Act, they would have to wait until the meeting of creditors. This is making provisions for this step to be taken even before the meeting of creditors. So it's a good recommendation, and we are saying yes, we should adopt it in our Act. In the CARICOM model, yes.
Sorry, can you turn on your mic?
I'm sorry, I was just confirming that what was proposed it already exists in the CARICOM model. And
Yes.
I was just accepting what she had proposed there. It makes sense.
Yes, it follows. Any other comments or objections from members? None, then we accept 28A. Next.
This is 38.9. This is also a new section by PBCJ. Sorry?
We're at 38.9, not 39.
38.
But it would come after 38. It would
This is
come after
38
38.
subsection 9. This is 38.
It's okay. We will help each other. We will help each other. We're now dealing with 38.9, which will come just before 39. Go ahead, please.
And this is a recommendation from the PwC to incorporate a cross-class cram-down where the court can impose a reasonable restructuring plan on dissenting creditors. However, there is a recommendation for an amendment that a provision be included for debtors whenever creditors unreasonably withhold their consent to agree to the proposal for them to go to court. That's not in the provision now, and we are of the view that if that is allowed, we'd have the same. It will result in the same.
So
Yes.
what is your recommendation?
That it be, that the amendment be, not the cross-class cram down, but that there be an amendment to give the creditors the authority to, the debtor, thank you, the authority to go to court in the event that the creditors withhold their consent unreasonably or unfairly.
All right, and so that puts it in a place where a decision can be made rather than you argue and argue. You want to argue, go to court.
Certainly.
If you can't come to an agreement, you know where you're heading to court.
We're heading to court.
Senator Allen.
So just so I'm clear, the recommendation that the ministry is making is in the final column on the right, which is with this
Yes.
14-day.
Yes.
Okay.
Yes.
Okay.
I have paused, no comment. It means the committee will accept this and we go forward. Accepting 38.9 as a new section, as proposed in the matrix. And that now takes us to
It would be,
a long overdue number 7, item number 7, which deals with section 39, which is Senator Allen's favorite section today.
and I could do a little further explanation for 38.9, Minister.
Please go ahead.
38.9, the amendment will be in section 40. So the new section would be section 40.
Which is just below.
Which is just below. We're
All right.
not there yet.
But please don't skip 39. So don't skip number 39. We're not going to deal with right or wrong. That's what the court is there for. We are not a court, so we will continue with number 39, which is
39.
item number 7 on the distributed sheet. Thank you, Senator Allen. Go ahead, please.
The section will be amended to insert a provision that where there is no objection, the supervisor will certify the deemed court approval. So the section, the act provides that after 30 days after filing of a proposal, serving it on the creditors, if no one objects, it is deemed that the court approved the proposal, but there is nothing to certify that approval. So the supervisor will now issue a certificate of approval after the 30-day period. Yes.
Okay. Right. There seems to be no objection. We will accept 39 as outlined. Senator Allen?
Yes, but in here it refers to 15 days, but you just said 30 days.
It is 15 days. Thank you. Thank you.
You see, it's
Thank
my
you.
favorite. It is my favorite section.
She's on it. She's
I'm on
it.
section 39.
She is on it.
No, it is 15 days. Thank you. Yes.
So it's what?
15 days is correct.
15
After
days.
15 days.
After 15 days. And those are not 15 working days. Those are 15
Those are just
calendar days.
15 calendar days.
Yes, okay.
Yes,
Thank
Minister.
you. We move now to section 40.
Section 40, yes. Amend the section to provide for debtors' right to appeal when the proposal is refused within 7 days. That was PwC's recommendation. This is now the recommendation we are accepting to say yes. Include this, but we are of the view that it should be 14 days, 7 days.
Rather than 7.
Rather
is
than
short.
7. 7
Yes.
is too short, yes.
Okay. I don't think we have any disagreement with that. The committee accepts section 40 as submitted. Section 41.
Section 41, for clarity, includes circumstances contemplated by the
This is
CARICOM
Jambar.
bill.
This
This
is
is Jambar, yes.
And what you're recommending again?
That the language proposed in section 72(1) be adopted. Okay. Yes. And we're going to that, it is section 11, section 41. Could you please read that for me? Yes.
Section 41. What are we doing
We are
here?
reading from the
From the mother document?
other document.
All right, go ahead, please. On page, tell us.
On page 11.
Okay.
It reads, a proposal accepted by the creditors and approved or deemed approved by the court does not release the insolvent person from any particular debt or liability referred to under Section 216(1), unless the proposal explicitly provides for the compromise of that debt or liability and the creditor in relation to that debt or liability voted for the acceptance of the proposal.
All right.
So that is bolstering our Section 150, where debts are not released in bankruptcy. Now we are including these provisions in at the proposal stage, which is
Where it should
recommended
be.
and required.
Right.
Yes.
Right. I don't think we have any disagreement with that. So the committee will accept that submission.
41A, it's a new section as well, recommended by Jambar. Important steps to enable a viable proposal regime as contemplated by the Caribbean Model Bill. This is 41. That's your recommendation 1, page 1 of your mother document.
Okay. Recommendation 1, that long recommendation.
Yes, it is so long. And those are included as 41A and 41B, 79, section 79,
Yes.
section 78.
Sections 78 and 79
And 79.
on
yes.
page 1.
On page 1. Okay.
Is there anything we should you should highlight on this, Ms. Allen, Lawyer Allen? Or Miss Roberts?
Section
Evans
78
Roberts.
provides for the court to assign rights and obligations of the debtor. It is not presently in our act, and we are recommending that it will make our act more viable. Again, they're concentrating on the proposal regime, which is
The rights and
obligations of the debtor. So the court may assign them in certain circumstances.
I don't think anything is wrong with that. And 79?
Disclaimer of agreements. Presently, only bankrupts under our section 263 may resile or disclaim agreements that are not in their favor. The proposal, the debtor under the proposal regime cannot do so. This provides for the debtor to be able to do that.
All right. Again, codifying some of the rights of the debtor
Certainly.
that were not there. We don't seem to have any objection to this, to 41A as submitted and recommended by Jambar. So we accept that and go forward. We go forward to 42B, another recommendation
42.
from Jambar.
42A.
42A
A.
is on the circulated document?
Yes, it is.
Okay, go ahead.
Yes, it is. That's a recommendation from Jambara as well. Out of an abundance of caution, include general power of the court in relation to proposal. Yes.
No, I
However,
mean, wait just a minute. I jumped from, on the circulated document, we jumped from 39 to 47. But we're addressing 42B on the matrix.
Yes.
And that is referring to the CARICOM bill,
Yes.
which is on page what of the mother document?
Page.
You have to find that on the mother document.
That is on page 3.
Of the mother, okay, go ahead.
Page 3, recommendation. Recommendation 3.
All right.
Yes, we recommend the inclusion of a new section out of an abundance of caution, which expressly deals with the general power of the court as it relates to proposals, as is included in section 84 of the draft CARICOM model bill.
Section 277.
Yes, our section 277 says it empowers the court to decide all questions whatsoever that may arise in any case of insolvency. We're of the view that that's a general power of the court. They already have that.
So what are we recommending here?
We're saying
You're
that
not
this
accepting the John Barr recommendation because our existing laws give the court that authority already. So there's no need to repeat it.
Well said.
That's your point.
Well said, Minister, yes.
All right. Thank you. Seems to be clear to somebody from St. Elizabeth, so it must be clear to everybody. Which means that we accept the JAMBAR recommendation of 42B and move on.
Yes. And 42B, a new section as well, and that's also on page 3 of the mother document.
You're addressing 42A now, right? We just dealt
We
with
just did
42B.
42A.
No, we just did 42B came before 42A on the matrix.
It did?
It did.
sorry.
So you addressed 42A.
Yes.
All right. Now 42B is found on what page of the mother document?
Page 3,
Same again.
same page 3.
And
That's our
recommendation 4?
recommendation 4.
Okay. And what Jambar and CARICOM are saying
They're
there?
saying the court may, on the application of any person interested in the matter, make an order removing from office any director of a debtor in respect of whom a notice of intention or a proposal has been filed, if the court is satisfied that the director is unreasonably impairing or is likely to unreasonably impair the possibility of a viable proposal being made in respect of the debtor, or is acting or is likely to act inappropriately as a director in the circumstances. The court may, by order, fill any vacancy created under subsection 1. And we are agreeing to
You're
the
agreeing.
addition of this, yes.
Right. No, just for clarity for me, my recollection that you did not agree to 42A by Jambar.
We did not.
You did not. However, on the matrix it said insertion provides clarity. Which insertion?
That's for 42B.
That's a 42A. 42A, which you dealt with first. 42B is listed first, but 42A was dealt with, and you said you did not agree.
Okay. It's the other way around, Minister. It's an error. I'm sorry.
All right.
We are sorry.
Can you outline exactly what you're saying about 42A and B so we have it right for the record?
So on the mother document, page 3,
No, go to the matrix, please.
matrix,
Which item are you dealing with first?
42A.
But 42B comes first on your matrix.
Okay. 42B, the general power of the court in relation to proposal is, we are sorry. So we are having two different ones.
Yeah, A should have been listed
A should
first,
have been,
but
yes.
B was listed. And you dealt with A, is that right? No, no, she said she dealt with A, not accepting what
Yes.
Jambar is recommending.
Yes.
And we broadly agreed with you because you said the court has the right already for all insolvency. So the note on the right-hand side should not be that. It should be that we don't agree.
Correct.
So I'm going to write it on this, and the record for Hansard should show that the matrix, the comment on the right-hand side of the matrix for 42A is incorrect. It should be that we do not agree with the Jambar recommendation.
Correct. Thank you, Minister.
Now, can you address 42B
B, yes.
by Jambar again?
And we agree with this one.
Okay.
Yes, and we read it before, and it's the insertion provides clarity and empowers the court to remove directors at the proposal stage. Yes. Yes. Correct.
Okay,
The
so
provi-
now
we did read
we're back in order. 42A is not accepted, 42B is accepted. That insertion is accepted. All right?
Thank you,
From
Minister.
Jambar.
Yes.
We can now go to...
Chairman. Chairman,
Yes, Member Hilton, go ahead, please.
just a query. while I understand the support for the proposal in general, what happens in the instance where the directors could, because some companies now all you need is one director. What happens if the sole director is being replaced in those circumstances?
Are you referring to section 42B? Okay. So we're discussing that. You want to address the member's question?
Is the provision sufficiently provide for those instances or those particular circumstances?
The section is providing that whenever there is a director who is going to be impeding the progress of the proposal, the court, I don't think the numbers matter. If there is a director that is impeding the acceptance of a viable proposal, the court is empowered.
The court is empowered to rule.
Always within the discretion.
To rule on it. They can rule on it.
Yes, the discretion of the court.
But Chairman, it does matter, because what Member Hilton is saying is that if you remove the sole director, then you don't have a board in the company.
Yeah. And all I'm asking is, so I understand, I understand the rationale.
The power of the court, but your question is somewhat different.
Yes, my question goes to that practicality and the practical situation that arises, and whether the proposal that we're accepting sufficiently takes account of those circumstances.
The trustee is the person under the proposal regime that is administering the proposal.
Correct. But the court is,
additionally, Minister Hilton, the court is empowered to fill a vacancy. So if it's one director, I can see the court removing that director, but filling a vacancy as well to make sure that a board is still in place if required.
So the court has broad powers.
Certainly.
To remove, to fill, to accept, or not.
Yes, Minister.
Does that explanation satisfy you, Member Hilton and Senator Golden Campbell?
But for me, I just want to know that, because so the grounds are that the director is likely to be unreasonable.
Unreasonable, impairing, yeah.
Impairing the proposal, which is a reasonable proposal, a viable proposal, you say. And so a director, the court fills that position for purposes, perhaps the operation of law, fill the position. But see, what troubles me is who the question I have in mind is who then looks at the interests of the company. I suppose you said the court, and great powers are given to the court in these circumstances. I suppose that will require, in the way that that pans out, it probably requires some kind of a mini hearing to determine the unreasonable before the director is released. I'm just wondering. I'm just concerned about if we have any safeguard for the company's interest and what remains of the company's interest. Again, on the basis that these proposals are being put forward with an objective of not closing companies that are viable companies, and for good, sound public policy reasons. Yes. And that, I'm just a little concerned in those particular circumstances, not in the general. I understand the need for the proposal generally, and we can come back to it. I'll give it some more thought and have some further discussion. But that one I would like us to be assured that we have given full consideration to the particularities of those situations as they arise. I can be persuaded. I'm not immovable. I can be persuaded.
And you're mentioning when there is only one director in place, Minister?
One director. Which happens quite a lot these days.
And that trustee would have been appointed by that director. And I think we're saying that in the case that director is unreasonably impairing the acceptance of our presentation of a viable proposal, we're saying empower the court to do otherwise if for the interest of the creditors on a whole, the best thing is
or
that
the company
proposal, or the company, yes.
Yeah, I know the creditor's interest will always be taken fully into account. I'm satisfied. And they are not the ones that would be affected. My concern is what of the company.
I think unreasonably impairing is important there, Minister, because this would be the director's proposal, but now the same director is now unreasonably impairing, and we're saying empower the court to remove the person.
Yeah, I understand. But my only point here is that that's a fairly drastic thing. And so my question is, are there any opportunity for any safeguards? So I understand the thrust of the proposal. I just want to ensure that we understand this is a particular set of circumstances, and whether there are sufficient safeguards in place. Rather than the broad statement, I accept the broad principle.
Yes.
Except I'm just talking about the particularities of the situation, not the unique, but the particular circumstance where it's one director, no one. Well, you're correct in that they would have been involved in the appointment of the trustees, the trustee, and therefore, anyway, let us hold on that and move on, Chair. I don't need to unreasonably detain the committee, but I'd like to be satisfied that we have looked at all of the permutations that may be involved here and made some safeguards. Because that's a fairly drastic power, which is necessary. I'm not disputing the grant of the power. I'm just saying, let us be sure that in its exercise, that we don't have some unintended consequences.
You're going to give this some consideration,
Yes,
well, yes?
Yeah.
So
right. And if we come back and say we've thought about all of that,
you give this some consideration, bring this back to us, bearing in mind what the question has been, and so we move on for this and defer a decision on this.
Guided Minister.
Excuse me, Chair, through you, I just wanted some clarity. My understanding from what the supervisor said was that the proposal for a new section 42A by Jambar for the removal of directors and filling of vacancy by the court, that was not accepted. But based on the discussion, it sounds as though it is being accepted as a recommendation. So I just wanted clarity on that point.
It is accepted. We had corrected the wrong reference. That one on your matrix says not accepted, but we had amended it.
Well, it says accepted for me on my matrix. It says accepted.
It is accepted, yes.
Okay, thank you.
You're welcome. Yes. There's no decision we are going to do further.
So you'll do some further work on this. All right, we defer this. We move to number?
Section 44.
Okay.
And this is an incorrect reference to the sections, so that will be amended. Will be corrected. Section 47, which is on
the circulated sheet.
On the circulated sheet, yes.
Number 8 on the circulated sheet.
Number 8, section 47. The marginal note is being amended by deleting the words by the supervisor, because the supervisor is not the one who approves proposal. It is the court. So we are removing it to make sure that.
Okay, and that will be corrected. We seem to have no objection on that.
Section 48, sale of property. Yes. And this is a recommendation by Jambar as well. Include the considerations as contemplated by the CARICOM bill.
Yes, and
This is page 11 of the mother
document.
Document. But for this one,
All right, and what you're telling us?
for this one, unfortunately, the sections from the model bill is not there. So for this one, we're asking permission now,
To
Minister,
resubmit as well?
to resubmit this one.
That's
provide
section 44.
48.
48.
To provide the
Okay, resubmit.
submissions from the draft bill.
Okay. Section 53, is that where we go?
Section 50.
50.
Yes. Is next, effect of the annulment of a proposal.
Section
50.
50, that's number 9.
Yes.
And
This section is being arranged.
There's nothing written on the mother document either.
Right, it is on this, it's on the latest one.
It's on the, okay, fine.
Yes.
So what do you,
This was our,
yes,
number 9, amendment of section 50.
yeah, I see that. Can you just explain what you're trying to achieve here?
Its section is being amended to rearrange the order of the sections. There is a process for an assignment. Somehow the sections have them.
You want to have them aligned in the right
yes.
order, all right?
Correct, yes, we want to have them aligned in the right order. And there is a mention of 21 days in that section as well.
Yeah,
So that will be amended to the 30 working days.
okay.
Yes. Yes, and there is a reference to an order annulling a proposal has been made in the section. It is really the certificate of assignment that has been issued. So there are 3 amendments to that section. We are going to
That would be
rearrange.
yes.
We're going to remove an order annulling a proposal and replace that with a certificate of assignment has been issued. And we're going to amend the 21 days to 30
working days.
To 30 working days.
Right. Any queries or comments on the suggestion for number 50, section 50? None, then the committee will accept that. It's now 11:30. We have gone through quite a bit here. We have some things to resubmit. I'm going to ask the committee if we will adjourn at this stage and come back for a time to be delivered. But we want to make sure the next sitting will take us right to the end. Okay?
I think it will, Minister.
Otherwise, I'm going to begin to lose committee members. Senator Allen has already left. So let's adjourn here. I'm going to ask Member Miller to move, and Senator Golden Campbell, if you're still there, to second, that we terminate today's meeting at this point.
It moved, Chair, I'm seconding.
Yes, you're seconding. Member Miller moved. Thank you so much. We will, Madam Clerk will get in touch with us for an appropriate date. We want to get to the end of this quite quickly, and the resubmissions will be made at that time when we return. So thank you all for coming. Appreciate it. Bye-bye.
Thank you, Minister.